Hi, I'm Dan Krause, and today I want to talk about powers of attorney, specifically how you can make the statutory Wisconsin power of attorney much better if you decide to use that power of attorney. Once again, my name is Dan Krause. I am an attorney in Wisconsin. I'm also licensed in Illinois and Minnesota, and I do estate planning and elder law and probate. I have a law firm called Krause Estate Planning and Elder Law Center, and we help elders and their loving families to preserve assets in the face of taxes, the devastating costs of nursing care, and also predators. And today I want to talk about powers of attorney, like I said. I want to tell you a little story. I had somebody come into my office the other day, and they were concerned about their mom. Mom has some assets, a house, and maybe about $200,000 in savings and investments. And mom is in need of nursing care. The family was unable to continue taking care of her. She had slid down the slope of old age far enough that she was in danger for staying at home. So they wanted to find out just how much of her assets they could save for her benefit during her lifetime, but still qualify for Medicaid, which could pay for nursing or long-term care costs, assisted living, memory care, that kind of thing. So I said, that's great. We can help, perhaps. Is your mom competent? Can she sign documents? Can she make decisions on her own? No, mom's not competent. Well, does she have a power of attorney? Yes, she does. Are you named as the agent on that power of attorney? Yes, I am named as the agent on the power of attorney. That's all great. Can I see the power of attorney, please? And sure, here's a copy of the power of attorney. The power of attorney was the state form, and right away I thought, uh-oh, this may not be a good sign for this family. And I paged through it and I saw the there were not enough powers on the state form that were filled out in order to help. Specifically, there were no gifting powers, while there were powers to deal with benefits from government programs or civil or military service. Unfortunately, there were not the powers to give away the assets to the family in order to preserve them. Gifting is a power that's not allowed, or not that it's not allowed, but it's not um, easy to know that you need that power in there, and you have to write it in on your own on this state form. So, unfortunately, we're unable to help that family save $250,000 for the care of their mom and the security. They had to spend it all down before they could qualify, or the mom could qualify for Medicaid to pay for her care. So I want to talk to you about the state form, and there's things that you can do to improve the state form. First of all, though, I want to say that the best option is to get your powers of attorney from a qualified, experienced estate planning and elder law attorney. The estate planning and elder law attorney is going to have forms that are far superior to the state statutory form, even if you put the special language in that I'm going to tell you about. So by using the state statutory form, that's okay. You should have a power of attorney is better than none. By putting some special language in it that I'm going to share with you today, that's better. That's a second best. The best, though, like I said, see an attorney that's experienced in this area and get the powers of attorney drafted by that person and an entire estate plan, and that's going to serve you the best. But right now, I want to give you some language. So under the power of attorney, the one that you can download from the DHS website, the Department of Health Services website, and we'll give you the link in the comments or somewhere around this video. We'll give you the link. You can initial on the second page in several different boxes where you give your agent, that's the person who is taking the powers and being able to act on your behalf. You can give your agent several different powers by initialing in the boxes. And that's great. You can give them the power to deal with real estate, buying or selling real estate, to deal with tangible personal property like artwork, furniture, clothing, jewelry, etc., stocks and bonds, etc. There's many boxes down there, and many people just initial them all because they want their agent to be able to do whatever they might need to do. And then they think after initialing all those boxes, that's it. That should be everything. Well, it's not, unfortunately, as the story has told us. There's other things that people should need to be able to do. So there on the third page, there's a box that says special instructions, optional. Most people leave that blank because they don't have any idea what else they might need to put in there. So I'm going to give you some language to put in there, and there's 5 different sentences or different powers that I want everybody to be able to have. I want to preface this with power of attorney can be a dangerous document. If you give someone else the power to handle your financial affairs, to do all of these things, they can steal from you very easily, and it sometimes happens. So only give someone a power of attorney if you really trust them. Typically, it'll be a child, a brother, a sister, someone that a spouse, obviously, someone that you would trust your entire life savings with, and not to steal from you or use it or mismanage it in a bad way. So having said that, now add these special powers in there. So the first one is a general power. Just states that the person can have a general power to act in any circumstance where I could act myself. This gives them all the statutory powers under the state statute, but that doesn't include everything. So that's why we add another 4 powers. Power to make gifts is the next one. To make gifts of your property to anyone in any amount, including to your agent, to the person that you're naming in the power of attorney. Sometimes gifting is the only best way to save your assets from spending them down on the devastating costs of nursing or long-term care. To give them to your family so that they can hold them. The next power is to create revocable, or more specifically irrevocable, or more importantly, irrevocable trust to preserve your assets. The third power, or the fourth one, is to set up and fund a trust like a WISPAC trust. Now, this is a special kind of supplemental needs trust or a special needs trust that you can set up and qualify for Medicaid immediately. And the final one is to make loans of your property in exchange for a note as part of a plan to help you qualify for government or private benefits. If you add these in, it's going to significantly improve the ability of your family to plan in case you get incapacitated and you need very high cost services for your care, like nursing care or assisted living care. So that's my long tip for today. Hopefully you will take this to heart. And if you're the type that needs to do this kind of planning on your own, good for you. I do highly recommend that you get these types of documents from an attorney, but this is the next best thing. So I'm giving you some of the secret sauce that's cost me several years of experience and has caused heartaches to many of the people that I might have been able to help if they had this particular type of power of attorney. This is only one part of an estate plan. You should also consider your health care, your avoiding probate is always a good idea, etc. So if you've appreciated this tip and you would like some more, you would like to get on our regular mailing list for our newsletter, please email us at newsletter@friendly.law. That's newsletter@friendly.law. and you'll get all kinds of tips like this monthly, every couple of weeks, depending on whenever we send out the newsletter. And or you can give us a call if you need help with elder law or estate planning. Call us at 608-268-5751, and I hope you have a great day.